In a groundbreaking verdict, London's High Court has invalidated an $11 billion arbitration award in a case involving Nigeria and Process and Industrial Developments Limited, otherwise known as P&ID. Now, the court found that the award was marred by brazen fraud. This ruling provides a significant reprieve for Nigeria, shielding it from a massive financial liability. The story dates back to 2010, a contract that P&ID secured to build a gas processing plant in Calabar in Cross River State. But the company said that the contract failed because the Nigerian government did not fulfill its end of the bargain. Now, claiming Nigeria breached the terms of the contract, P&ID took a legal recourse and secured an arbitral award against the country. And on January 31st, 2017, a tribunal ruled that Nigeria should pay P&ID $6.6 billion as damages, as well as pre- and post-judgment interest at 7%. That $6.6 billion eventually grew to $11.5 billion through interest as Nigeria continued to fight the case. And Monday's verdict comes 5 years after the international legal wrangling began. Joining me now is Tolu Adiremi, partner at Perchstone and Grays LP. We've been following the twists and turns with him over this past year and a half in terms of this particular case. Tolu, welcome to Business Edge once again. It's good to have you.
Thank you, Tolu, for having me.
So this case has captured attention, not just for the issues raised around the contract processing and all of that, but also for the total amount that Nigeria would have had to shell out. And in his ruling, Judge Knowles ruled that the awards were obtained by fraud and that what had transpired in the case was contrary to public policy. So Tolu, let's start from there. Nigeria has maintained that the contract and the award of the penalty were fraudulently obtained. Take us through what the judge would have meant with against public policy in particular.
Thank you very much again, Tolu, for having me. I think it's very simple, and it will take it very quickly from the efforts of the Economic and Financial Crimes Commission. We must, and I've listened to quite a number of people, I've not really seen anyone who's given the EFCC or the Anti-Graft Agency the relevant recognition, because 80% of the information used in the commercial court in London for the court to come to the conclusion which it has come to were outcomes of EFCC's investigation. And so I will start with that by giving EFCC that recognition. Now, as it relates to your direct question, which is whether or not it was contrary to public policy, I think the answer is quite simple and straightforward. The investigation of EFCC, which, if you look at the about 140-page judgment, the court took us through, and I must say that I've not completely read the entire judgment, but the ones that I have read, the court took us through the entire process from the negotiation of the contract to the signing or the execution of the contract, the roles the civil servant played in executing the contract, the role the Attorney General also played in the execution of the contract, and quite a number of things, and everything and every step that the judgment detailed, unfortunately, were less, one, than transparent, two, were less than effective, and three, did not reflect our national interest, particularly because it relates to our Commonwealth. And it was for those reasons the courts came to the conclusion that it came to.
Okay, so you bring up the EFCC, and it's actually one of the questions I was going to ask you, because many have pointed to the fact that that was a major turning point in the P&ID case, and that was when then Vice President Yemi Osinbajo actually recommended to then President Muhammadu Buhari that the EFCC get involved and independently investigate all the relevant circumstances. The president approved this, and then he also asked the National Intelligence Agency to also join the investigations. So given what you said in terms of giving the EFCC some credence for the victory that came from the court yesterday, how much do you think we really should be grateful to them in terms of that being a major turning point for Nigeria in this case? And what was the evidence in particular, let me add that they brought forth that you see was really something that the judge obviously could not deny?
The truth of the matter, Tolu, is if you've read that judgment, most of the findings of EFCC will not make me celebrate the victory which everybody seems to be celebrating. When you look at the conduct of key government officials when you look at the sums that was being paid out. Even when you look at the alleged sums that was also paid, by counsel in this matter, it was a bit embarrassing. I must be honest with you. And I asked myself when I was reading that judgment to say, look, what has happened to our contractual process? What has happened to the gate checks, particularly when it comes to state contracts? I mean, when you read the judgment of the court was singly or seemingly advising government on how it must implement or execute its contract. But let me go back to the EFCC. The clear evidence from EFCC were the outcomes of its investigation. So EFCC interrogated almost everybody involved in the line of the execution and purported implementation of the P&ID contract. Central to all of this was a woman called Mrs. Tiaga or something. She was the legal director of Ministry of Petroleum at the time. And she played a central role, whether as it relates to persuading the then Minister of Petroleum to sign the contract, whether she advised the minister appropriately as to what the obligations of Nigeria will be under the contract, as opposed to what the consequences of not fulfilling those obligations were. Now, all of these, you will be embarrassed to now see the sums of monies which was being transferred to her, whether directly into her account or into her daughter's account for payment for health, etc. To be honest, I feel very sad. And just not her. You will see the indictment on the Nigerian police. You will see the indictment on the Nigerian military. It's a potpourri of sorrow, I must say. But again, I will give EFCC, that kudos, because it was from those investigative reports that the court was able to come to that conclusion. And even the Nigerian government was able to lead evidence as it relates to the case of which was just completed in the commercial court in London.
So this raises the issue that I've raised with you many, many times. What is Nigeria doing on this side of the conversation, on this side of this case, with those who were involved in fraudulently coming about with this contract process, even individuals like in Adebayo Adebayo, who Nigeria also alleged was in receipt of a slush fund to be able to bribe Nigerian officials during the settlement negotiations after the 2010 contract. Then in terms of the situation where Nigeria is now trying to settle, there were obviously officials inside who were working against the Federal Republic of Nigeria. So we have this case internationally with P&ID, but we also have a case internally as well. What's the update? Because even from the last conversation we had, it hasn't seemed that there's been much progress in Nigeria prosecuting those on this side of the equation.
The simple answer is the effectiveness of the rule of law. So we've seen the effectiveness of the rule of law. The entire trial, I mean, like you also followed, took 8 weeks, in the UK. If we were to do that in Nigeria, and it's ongoing in Nigeria, I must say. But again, like our criminal justice system has its own challenges. We're working on it, but I think it grinds slowly, but it will grind surely. But let me go to a question that I think you asked earlier, that what is next? I think that question came from your early opening statements. I think the matter has only just begun to.
And to next yet?
If Nigeria, yes, it's only just begun.
I don't want us to go to what is next just yet. Just hold on for me, because that what is next is, unfortunately for me, a lot of people are not focusing on that part, and I want us to wrap the conversation with that, because I hear that the court has 3 options. But before we get to that, when we look at the witness situation in this trial, it was very tricky. And what we saw was that several key witnesses were either unable or unwilling to give evidence. I mentioned Adebayo earlier. He refused to testify in court. How much of an impact do you think that had on P&ID's case? And I'll even ask that because the major shareholder, the controlling shareholder for P&ID, VR Capital, and there are a number of people who would have shared this 11.5 billion naira fund money if we had lost. They also alleged in a secret lawsuit that P&ID had in fact made unlawful payments to Nigerian public officials. So the controlling shareholder in the company is saying, I know that the company was doing illegal things. P&ID, because of some of the witnesses that eventually came out, said, okay, yes, we have to say, yeah, we finally found out apparently that there was some illegal maneuvering. In terms of the witnesses or lack thereof, how much impact do you think it had on the case and the victory for Nigeria in this situation?
I think it came out from the experience of the judge who sat over the matter. There were quite a number of witnesses that could have lent more credence, whether to the P&ID side or whether to Nigerian side. Unfortunately, there was a lot of changes, whether through biological or natural transition. So, for example, the lady I mentioned, Mrs. Grace Tiagana, whatever her name is, she passed on. So she really couldn't give evidence. The minister, former Attorney General of the Federation, Malami, at the time, when he came in, also did not give evidence, even though it was central to quite a number of the later parts of the issues. Mohammed Bello Adopi, who was the former Attorney General, could not also not give evidence. On my own side, which is the legal community, the counsel who represented Nigeria, Quashes, National Advocate of Nigeria, again, was not invited to give evidence. Now, where you have all of this, it goes a long way to impact upon the quality of evidence that the court will rely upon. But what this judge did, to my mind, which I thought was beautiful, and it came out, from his experience, was to, in cases of those who had given written statements before, but were not able to adopt their statements and could not be cross-examined, or those who had not given statements at all, but in the course of the pleadings, you could infer from, the judge was able to place value, evidential value, on those statements that were given, or the references to some of those key witnesses that could happen. For example, when you look at evidence of, or the reference to the evidence of grace, it was easy for the court to come to a conclusion that all the payments that was made purportedly by P&ID into Grace's account, into Grace's daughter's account, etc., whether before the execution of the contract or even after the execution of the contract or before the commencement of arbitration, all of those payments quite naturally must lead to something, which is corruption. So that was the way, the court was able to come to its own conclusion. Even the Michael Quinn, if you observe, he also passed on. That's on the side of P&ID's case. So there were quite a number of evidential constraints on the part of the court. But the court relied heavily, one, on references made to their conduct and their statements, and it was able to draw a very reasonable conclusion thereon.
I want to break down, before we get into what impact this could have had on Nigeria, I want to break down the 11.5 billion and how P&ID may have spent the money. So it's estimated that VR Capital, which I said is the controlling shareholder for the company, would have got about 25%. That's about 2.9 billion. Then Lismore Capital would have gotten 75%. But that breakdown is where things are interesting. There's a Seamus Andrew who would have gotten about 35%, about 4 billion. A Brandon Cahill, about 40%, about 4.6 billion. But they are also the ones who would have funneled the money to the Nigerian officials. You've mentioned Grace Tiaga. She was expected to get about 500,000. Adetunji Adebayo, or the Adeyanju Adebayo, about 10%, about 1.5 billion of the funds. Mohammed Kachazi, who's a former business associate of P&ID, was expected to get about 3% of this breakdown. Then you have a Neil Murray, several millions, and Adam Quinn, more than 2 billion, and a Trevor Burke, also getting some 10%, about 1.5 billion, which would have come from Seamus Andrew. So there are lots of people invested in P&ID getting this particular judgment in their favor and moving forward. And you can see the breakdown on the screen. A lot of people, and unfortunately, yes, Nigerians were involved. But when we look at the ramifications and the potential consequences for Nigeria's economy, Tolu, what would they have been? if the country had lost. This amount of money is several times over what we even spend on the health sector. And government likely would have refused to pay. Another legal battle would have started, and then the company would have probably attempted to sue and look to seize Nigeria's foreign assets. What kind of mess would it have been if we had lost at this level of the case?
But actually, the blunt truth, we would have had no choice. The country would have been plunged into a financial pit hole. Don't forget that the matter in court really is for the enforcement of the award. And it looks to me like sometimes people are overlooking that point. If the court were to enforce that award, and you remember our last conversation in respect of this, I had said for the court to determine that there was prima facie case established by Nigeria, it was almost likely the results would be this. If they were successful in enforcing that award, we would have had no choice. Nigeria would have been plunged into a big mess. Of course, enforcement of an award by the trial court does not also mean the country must cough up that money. Two things are likely to happen. The first is that the court or the losing party, in this case Nigeria, will have an opportunity again to also appeal on that point. Second is in arbitration and even in enforcement proceedings, you still have an opportunity to negotiate how the judgment debt is to be paid. So I expect that, even if we lost and the court was got ruled in their favor by enforcing that award, we will still have been able to sit down and see how we can negotiate the payment, or we will still have a right, to appeal that decision.
That question you were anxious to answer.
Thank God we did not believe.
Very much, I know that's right. So that question you were anxious to answer, that's where we're going to wrap things up, because it's very important. While we're celebrating the victory and across the front pages of newspapers in Nigeria, it is a victory, but it's not exactly over. So while the High Court judgment is, of course, a major victory at this point in time for Nigeria, it's not the end of this very messy situation. So the court is yet to decide what will happen to the fraudulent $11.5 billion award. And that's going to be decided in a future hearing. So there are a few options, according to what I've been reading. 1, send the award back to the arbitration tribunal for reconsideration. 2, cancel the award in full or in part. Or 3, declare the award to be of no effect. Tolu, as we wrap up, take us through the potential consequences of each option and what you think likely, looking into your crystal ball, could be the eventual decision in this case to finally end Nigeria versus P&ID.
If I was to look into the crystal ball and read into Justice Null's mind, I will say that he would prefer the second option, which is to set aside that award. And the reason being that in law and in practice, once an award is procured by fraud or fraudulent means, then such an award becomes invalid. And the only option the court will have is to set aside that sort of award. If that award is set aside, particularly on the point of question of fraud, if that award is set aside, does it leave a P&ID with an option of also appealing that decision? Oh, yes, indeed. They might also, have the opportunity to appeal that decision. So I think going forward, what we should expect, and don't forget that the decision of Justice Knowles yesterday is also not final. As to the order to be granted, having seen the mind of the court, there will be consequential orders. The consequential orders were the 3 things that you have just described. And the court has invited counsel to come and advise it or to come and address it on why it should be option A and not option B, or why it should be option B and not option C. But like I said, if you ask me, on the preponderance of evidence that the court has relied upon, I think more than likely, and regardless of, the address of counsel on both sides, the court is likely to go with the second option. But Olu, before you close, and I know you're itching to close, I think there's an important point that we should also take away. And that point is, what should we take out of this as Nigerians? There are 3 key issues, and I will quickly run through them. The first one is, what are the ethical framework for public servants' duties? If you look at the genesis of this crisis, yes, P&ID They may have had the intention. In fact, Justice No said it didn't look to him like they had the intention. But as things went on, they had intention of getting this money through arbitration. The role of the public servants in all of this troubles me slightly. And as public servants, do we have code of ethics by which public servants are guided and conducted? Because if we hadn't gotten this judgment the way we got it yesterday, the public servants who were involved would have plunged our country into crisis. That's point number one. Point number two, how do we negotiate big ticket transactions, particularly transactions that relate to our commonwealth as a country? A legal director advised the honorable minister to sign a contract. The minister not having read the contract, of course, the minister won't be able to read all contracts. It's your job as a legal director to summarize. And what are you really summarizing? Rights, obligations, and liabilities. And so if a legal director is not able to understand those basic elements of contracting, then we are in serious trouble. And finally, I think it's important, and we dealt with that in one national assignment we had recently on the national arbitration policy. Any contract going forward that relates to our commonwealth must have certain benchmarks. One, who and where the arbitrators are appointed from. Two, the quality and expertise of who the arbitrator and counsel is or are. A number of those things, we have addressed them in the arbitration policy. And I'm hoping that the Nigerian president, President Tinubu, will quickly call for that document, have a look at it, and approve it as the national arbitration policy of Nigeria. Is quite important. And this will cut across all MDAs. We must have the same standards by which we deal with contracting and dispute resolution in Nigeria.
All right. So, and even much as I know time was not on our side, Tolu, you actually did look into your crystal ball, because my last question to you was about the key takeaways. Have we learned our lesson in this situation? And given the fact that the history, the antecedents of P&ID, even before that contract process, were basically non-existent. So it does beg the several questions you've listed out here. But Tolu,
but Tolu, do you?
Yes.
Tolu, just before you go, do you realize that P&ID has been operating in Nigeria since 1999? If you look at the judgment, so he's been part of several contracts in Nigeria since 1999, and so how nobody was able to pick out this company, pick out the ethics or otherwise thereof of who this company and its promoters are, worries me slightly. There are a number of things we need to tighten up. So this judgment, good. Thank God the country is not indebted in the way and manner they had planned it. But I suspect, or I expect rather, that the Honorable Attorney General of the Federation and key government functionaries will pick this judgment. It becomes a learning document.
Yes, yes,
and we'll
a
go
case
and
study.
sit in a retreat and look into it as a guidance document.
And I know there's going to be much more, 140 pages, as you said. I think I made it through about 50 of them, but there's an exposure, as you said, as to how Nigeria exposed itself to this level of corruption and this level of situation. So Tolu, we know there's going to be more on this. Thank you so much for joining me from London. We'll be having more conversations with you soon.
Thank you very much, Tolu, for having me.